respondent on behalf of J. Abedin, madam.
Taking the consent.
Yes, madam. I've taken consent.
Your Honor, there was a interim order. So the Stanley that may be.
On a request made on behalf of the respondent,
I don't know whether.
on behalf of the private respondent, matter is adjourned to be listed on when?
12th
When?
February.
When do you want?
After a week, madam.
On 4th of February.
Obliged.
Was an interim.
Interim order passed earlier to continue till the next date of listing.
Obliged.
Obliged.
Wait, your lordship. In item number 23, lordship, we have filed our affidavit, lordship, regarding container number 1, lordship, that may be called for, lordship. Obliged.
Ma'am, the matter my lord relating to settlement of a shop under the Dumduma Town Committee. Earlier months, there is a order one honorable court in the school find page 20. Page 20. And relevant portion page 23 and 24. Page 24, lordship. By this
Yes.
order, my lord, lordship find my lord, last para. In view of the aforesaid submission, the respondent in petitioner is disposed of directing the Dumduma Town Committee to decide the dispute relating to the allotment of aforesaid room number 24 within a period of 4 months. 4 weeks, my lord. But even after submitting the representations and the order of.
Mr. Nath, after how long have you
Thereafter, my
come,
lord,
after how long have you come to the court?
my lord, will find there was
Cause of action
contempt.
arose when?
Contempt was also there, my lord.
Cause of, when did the contempt was closed? When was the contempt closed?
Contempt closed, my lord, in 2014.
14.
But in the
These
meantime,
last 12 years, what were you doing?
thereafter, because my lord, there no information, I made statement, my lord, in para 9.
We are not entertaining this kind of opposition. Sorry. Show us your
Because-
explanation which is acceptable in nature. Coming to the writ court after 14 years. Cause of action has arisen in 2001. You have come after 25 years.
No, my lord, because of the fact that, my lord, 2010, there is a order, my lord.
And these are all
Thereafter,
private disputes. What kind of
2011,
shops between you, your father and the respondent number 6, we are not going to entertain.
lordship, 2011, my lord,
Heard,
I filed the contempt, my lord.
heard. Sri S. Nath. Learned counsel.
So, my
So-
lord, my only prayer is that, my lord, representation is pending, my lord.
We were not going to, we are not a post office.
They have heard.
We are
the-
not a post office. You direct consideration representation.
They have
Sorry.
heard the matter, my lord, but they did not even pass the speaking order, my lord.
We are dismissing your petition. Heard 3S not learned counsel.
No, my lord, I may given time to take instruction.
No, there is no question of taking instruction. That's not requirement.
I may be allowed to withdraw, my lord.
May I withdraw it? Heard 3S not learned counsel for the petition. Right? Heard 3. K. Gogo, you are state counsel.
Lordship.
State counsel. Para, at the outset, comma, the aspect of inordinate delay and laches in approaching this court had arisen. Put up at this stage, the learned counsel submits that he would withdraw this writ petition. Para, writ petition is dismissed on withdrawal.
Obliged.
Yes.
Maybe the lordship. This is a contempt matter, my lord. The WPC order is at page 11, my lord, annexure 1. And the relevant portion is at page 16, my lord. 6 months time was granted, my lord, for complying the order. Last paragraph, my lord, of the order.
Where are your representations?
So representation is my at page 17, my lord.
Heard
Wording of the certificate.
3 SP Das, learned counsel for the petitioner, who by means of this petition has alleged deliberate and willful non-compliance of the order dated 13/12/2024 passed in WPC 6649 of 2024 by the aforesaid order 6 months time was granted for doing the needful. Para? No, para no. The learned counsel has also drawn the attention of this court to the representation submitted for compliance of the order in question. Para? That notice be issued returnable by 6 weeks. Let steps be taken by speed post to 30 steps within 2 working days. List on 11th of March.
Lordship, I have also made party to the response number 2, the new incumbent, and a demand notice has also been suffered. That is at page 19, my lord. Problem.
My lord, this is the matter where LUF was increased up to 4.5 times.
My lord, in fact, this aspect was perhaps raised by my friend, the petitioner, in the pre-bid meeting. So this was considered. So I asked them to provide the original copy of the note, which was in the file, and why the explanation for why the value of the contract has increased is there in that note. Your lordship. Primary reason is that the period of the contract has increased from 2 years to 3 years. And your lordship, to arrive at the estimated value, they have taken the value which is otherwise, to arrive at the annual value, they have taken the value, the expenses involved in hiring vehicles per year. So they have multiplied it by 3.
But will it go up by how many times it has gone up, Mr. Nath?
My lord,
What is the present?
4.5 times, my lord. Earlier 4 crore, now 18 crore.
18 crore.
Yes. So one
This is
year
the
increase
explanation
without-
that has been provided.
And it
In the note.
minimizes.
So I asked them not to add anything since this was raised earlier. And this is the file note put up by the AGM to the Chief General Manager.
What is the present position?
The tender, the technical bids have been opened, they are being evaluated. So I asked them not to proceed since I gave an undertaking last time. It is at that stage.
And he will be technically non-responsive because of this not meeting of this criteria of 18 crore.
No, I could not participate because the micro, as per the policy of 2021, micro is considered as up to 5 lakhs, 5 crore. And as per this tender, minimum annual turnover is required 6 crore. So I could not participate, my first thing. Second thing, my lord, I
I will issue notice. Don't finalize anything, okay?
Very good.
But we don't want a matter of this nature to be stalled.
Very well.
You file your affidavit by the next date, we'll try to dispose of.
Very well.
Okay.
but if the price bid is open, there is no way I could participate, my lord.
We
That is
we have already indicated, we're granting some protection. Heard, Sri D.K. Nath, Learned Counsel for the petitioners who are aggrieved by a tender process initiated by the APDCL for procurement of vehicles. Full stop. It has been contended that the value of the tender has been unreasonably increased, which led to corresponding increase in the requirement of EMD, annual turnover, security deposit, etc. He has also contended that there is no exemption for micro and small units. Full stop. Para, the Learned Counsel has specifically submitted that the earlier tender was settled with the petition number 1 at an approximate value of rupees 4 crore, and without there being any substantial change in the nature of procurement, the amount has been increased to 18 crore,
Yes.
for which the petitioners would not be in a position, could not be in a position to participate in the same. Para? When this matter had come up for consideration on 22/1/2026, this court had directed Sri K.P. Pathak, Learned Standing Counsel APDCL, to obtain the instructions. Full stop. Sri Pathak, the Learned Standing Counsel has submitted that instructions have been received, and received as per which this issue was raised in the pre-bid meeting and was considered. Full stop. He has, however, submitted that the financial bids have not been finalized as yet. Para, let notice the issue returnable on when? 17th, can we have it on 7 or before that? 11th? 11th February, but you have to file your affidavit. 11th February, 2026. Who would be accept, for State of Assam? Sri K. Gogoi, London State Council for one? Yes. Okay, one, then others,
Sorry, I think it's. I think it's. No, 3, 4, others I think.
even six,
Yes,
two, then KP Pathak for two.
not 5.
Oh, you are for 5 also, 1 and 5, huh? K. Gogoi, then 2, 3, 4 and 6 by KP Pathak, Understanding Council. Extra copies, 3. Nath, the learned council prays for an interim order. Para. Considering the facts and circumstances and by balancing the equities, while this court is not inclined to pass a blanket interim order, it is directed that till the next date fixed, no, no, don't say like this. Don't open the price bids. Have you opened already?
I do not have the.
No, my lord.
I do not have the. My learned friend has that instruction that can be recorded by.
No, my lord, because as per the last order, it was, he undertook to not open the price
That is
bid.
why
That order is there.
That is not open likely. And balancing the equity is directed that till the next date fixed, the price bids of the bidders shall not be opened and the matter shall not be finalized.
Well,
Have the, though the technical bits are under evaluation, there is a possibility. Final evaluation is not complete, but I have been informally involved. That perhaps none of the bids we have received are responsive.
Then it will look,
So at least some,
we should not, should we record that?
so that may not be recorded, but if your lordship says that no final orders may be passed for it, that is the language used.
No, no,
Then
no
we
final
have-
orders of allotment.
Yes, then we.
No
can
final
cancel the
orders of
bill.
allotment be passed.
Very good.
Right.
If you-
But in any case, if the instruction is otherwise, file your affidavit before the next
Very
day.
good.
yes,
Very good.
well.
Yes, Mr. Kondawar.
Project to permit structure, my instruction is elevated. 2015 meter wala the,
2017 matter.
17.
so 15 wala the work was executed. All documents to show that my the details in the admitted by that amount.
For bill,
Deal, my lord.
where is the acknowledgement?
My lord, that is not there. I have already ordered due to urgency, my lord.
Then you have to, we can give you the liberty to approach the civil court. And you're already delayed.
Deal, but otherwise, my lord, there was a verification. Verification shows that the work has been executed. Joint
For the
with-
writ court, that may not be sufficient. If you go by Tamsher Ali,
my lord.
you have to have other, okay, we'll just close this. We'll give him liberty. Third Sri M.R. Kondawar Learned Council for the petitioner. Also heard Sri B. Gogoi. You appear for the PWD. Standing Council PWD. Standing Council. You can appear for all, you can, we can record it as AAG, Learned AAG appearing for all the respondents. Para. The instant writ petition, which was instituted in the year 2017, is with a claim for release of contractual dues, full stop. As per the facts projected, the petitioner, who is a registered contractor under the PWD, was allotted certain works relating to repair and renovations of major roads which were damaged in the floods in the year 2015, full stop. The petitioner claims to have executed the works for which a verification was also done on 14/9/2015. Full stop. However, the amount in question has not been released to the petitioner. Para. 3. B. Gogoi, the learned AAG, has however submitted that to entertain a writ petition of the present nature, comma, there has to be an acknowledgement of the liability as laid down by the Honorable Full Bench in the case of Tamsir Ali versus so-and-so reported in so-and-so. He has submitted that in absence of such an acknowledgement by the head of the department, comma, a petition of this nature cannot be entertained. Para. The Honorable Full Bench in the aforesaid case of Tamsir Ali Supra has laid down certain guidelines which are as follows. Para. Perusal of the materials on record, including the documents, would not show that there is any acknowledgement of the liability by the head of the department. Para. Not para. At the same time, comma, the claim of the petitioner cannot be at the same time, there are no materials to show that the claim of the petitioner is not bona fide, full stop. Para. Therefore, balancing the equities, comma, while this writ petition is dismissed, comma, the petitioner is given liberty to approach the appropriate civil court for redressal of his grievance. Full stop. If such a move is made, comma, the petitioner may take when 15, okay, we have may take recourse of section 14 of the Indian Limitation Act 1963 for explaining the delay.
May I please, Your Lordship? In this case, we have challenged the inaction on the part of the respondent authorities in settling the pending claims of insurance claim of the respondent, Lordship. During the pendency of the instant writ petition, around 80% Lordship has been settled. 80% Lordship. Last occasion, we have given the release, Lordship. And thereafter, in respect of two claim, Lordship, group personnel accident insurance claims, 7,58,307 is pending. And in respect of marine claims, 41,600,989 pending. Lordship. Total claim loss during the pendency of the is 3 crores. Out of that, around 80% claim has been settled. Now they have to take instruction regarding the.
Madam, you are for whom? Okay, what is your take? 17 matter, how long can you give you? 2 weeks will not grant, we'll grant you sometime. Today is 27th, we'll have this on 9th. You'll get almost 2 weeks, yes, 9th. Okay. Heard Sri K. Kolita, learned counsel for the petitioner, who has submitted that during the pendency of this writ petition, about 80% of the claim has been settled by the respondent insurance company. Full stop. Ms. Musahari, the learned counsel, appearing for the insurance company, respond numbers 2, 3, and 4, has prayed for some time to obtain further instructions. Para. Since this writ petition is pending since the year 2017, while this matter is adjourned, comma, it is directed to be listed on 9th of 9/2.
Highly obliged.
In respect of English matter also. Accumulation I have. There was also after going to the prayer also, it seems to say that I have to obtain further instruction. Whether it's status also as because we have filed the affidavit in 2023.
Yes, we have seen that. He has,
And we have.
you have filed affidavit 10/2/23, he has filed a rejoinder also.
Yes, sir.
17/2.
Yes.
But in respect of the, they have seven the one lordship. 8/9/2020 lordship. Whereby it is decided how many.
Okay, when can you be equipped with the instructions?
After 2 weeks, lordship. Because
Lordship may fix it for final hearing also because.
We'll have it
after
for
the-
disposal at the admission stage.
Yes, my lord.
Heard. 3. N.K. Kolita, learned counsel for the petitioner, as well as the K. Gogoi, learned state counsel. Para. Both the learned counsel submits that the matter can be taken up for disposal at the admission stage. Para. In view of the above, list for admission hearing on 16th of February, Monday.
Obliged.
Office note. What is this office note?
Well, the petition had expired, my lord, when I could not file, my lord, the substitution application. There is no contact as such in between, my lord. My lord, the lordship will give me some time, my lord, I'll write a letter because. Yes, my lord, that's there, my lord. The telephone is not, my lord, working, my lord, so I have to, my lord, write a letter to the legal yes, my lord. So lordship, there can be some time, my lord. Otherwise, my lord. In fact, my lord, and almost the entire amount is paid, only because 8
No,
lakhs.
then we close this. We close this. Because even if you file, you have to file an application for a bit. See, the last order said that list after,
Well,
if it is not filed within a period of 6 months, matter is to be listed. That was on 7/11/25. We'll record your submission. Heard. What was the cause of action?
my lord, here it's a contractual bill, my lord. Everything else has been paid. The security amount is still lying, my lord. Otherwise, everything has been paid. 8 lakhs and odd, my lord, remains, my lord. That's the only part, my lord. Otherwise, the contractual bill has been paid. Only the security amount, my lord, remains.
Matter could have been taken ahead with the substitution. It's an existing claim. Heard Sri M. Datta, learned counsel for the petitioner. Also heard Miss B. Bhuya, learned senior counsel appearing for the BTC. BTC, madam? Para. This. Oh. Okay, RDB, learned CGC, as well as Miss B. Bhuya, learned senior counsel of BTC. Para. On the last occasion, when the matter was taken up for consideration on 7/11/2025, Sri Datta, the learned counsel for the petitioner, had informed this court that the petitioner had expired and he would like to file appropriate application for substitution. Full stop. The matter was accordingly directed to be listed. If such application was not filed within a stipulated period of 6 months, full stop. Para. Sri Datta, the learned counsel, has fairly submitted that in spite of his efforts, no contact could be made with the family members of his client. Full stop. Para. In view of the above, this court has no other alternative but to close this writ petition with a liberty to the legal heirs to file appropriate application if so advised in
Right.
accordance with law. We close it.
Fine. Tip of the judge.
His pharmacy council, my lord, their licenses were cancelled. Similar order, then the lordship will dispose of it.
Mr. Bhuya,
Can be disposed of. Provisions for it will also like.
Mr. Das, Madam Decker, both of you give a corrected copy, we'll pass the same order. Okay, make the corrections here.
Sure.
If you make the correction in the order passed by this court, it will be easier for us. How many petitioners are there?
6.
6 petitions.
7.
Yes, 7 petitions. And others, facts are almost similar.
Similar. The provision for filing appeal after
Okay,
getting the
okay, yes,
copy.
yes, we remember. Make the corrections by pencil and give it to a court. Dispose of. VD Das, assisted by Ms. R. Decker and M. Bhuyan for health. Standing Council Health Department. Mr. Deori?
Mayor Paulus, my lord,
Yes.
this matter relates to payment of contractor bills. My lord, 4 bills has been kept in withheld. Your lordship may find in page 101. I have completed the works in 2001.
It's Public Works. Public
Yes,
Works
ma'am.
Department.
Yes.
Yes, Mr. Gogoi. Mr. Bhuya.
My apologies, Lordship. Lordship, regarding the earlier order, which has the chief engineer's letter written, we have also intimidated the department. They're able to. But unfortunately, Lordship,
We'll grant some time. Heard Sri S.K. Deori, Learned Counsel for the petitioner, para. Sri M. Bhuya, Learned Counsel appearing for the Public Works Department has renewed his prayer for the grant of some more time to obtain necessary instructions. Para. In view of the above, matter is adjourned to be listed on, when? Today's, on, 16th,
Lordship,
16th February.
Lordship,
Nice.
Lordship, Lordship.
Wait, please, your lordship.
Yes,
This case concerns non-payment of contractual due. Your lordship, then a verification exercise may be conducted. If they are genuine and admitted, it can be paid.
Where is the admission, madam?
There is no admission that the completion certificate
Admission,
The fifth-
that will not be enough
is not.
for a writ court. We have been consistently holding to writ court to pass an order, you have to comply with Tamsir Ali.
Physical progress certificate is there.
You have to approach the civil court. Yes, what do you say?
Lordship, there is no admission, and as per Tamsili, the head of department has to admit that.
Have you got the instructions?
No, Lordship, still awaited.
Okay, get the instructions, but otherwise, madam, we'll have to remit you to the civil court.
I'm ready to do that.
So let
Then,
them
we'll
approach the
close
civil
this.
court, Lordship.
Heard, Miss B. Chaudhary, Learned Counsel for the petitioner. Also heard, Sri R. Gogoi, Learned Standing Counsel.
PHE.
PHE. Correct. The present application under Article 226 of the Constitution of India has been instituted with a claim for release of contractual dues, full stop. It is contended that the petitioner was allotted a work of horizontal boring in the embankment at Dokhin, Laskar, Pathar, PWSS within bracket group 1. However, the dues have not been cleared, full stop, para. Cleared. Accordingly, the present petition has been filed, para. Sri Gogoi, the Learned Standing Counsel, has at the outset submitted that to entertain a writ petition and pass orders for release, of the petitioner, the petitioner has to fulfill the requirement as laid down by the Honorable Full Bench in the case of Tamsir Ali versus Swenson, wherein amongst others, there is a requirement of acknowledgement of the liabilities by the head of the department, full stop. In the instant case, there is no such acknowledgement, full stop. He has also raised the issue of delay in approaching the court as the work was of the year 2014,
16.
as 2016, full stop, para. Miss B. Bhuya, Miss B. Chaudhary, the Learned Counsel, has fairly submitted that though there may not be an acknowledgement in writing by the head of the department, there are sufficient documents to show that the work was successfully executed and the amount has been unreasonably withheld. Full stop, para. The Honorable Full Bench in the aforesaid case of Tamsir Ali Supra has laid down the following guidelines qua a writ court entertaining an application for release of contractual dues, which are as follows. Amongst others, there is a requirement of acknowledgement in writing of the dues by the head of the department. Full stop. In the instant case, there is no such acknowledgement by the head of the department. Full stop. However, this court has noticed has noted that there are certain documents which may form part of the claim, which may lend support to the claim, which however is required to be raised in an appropriate civil court. In view of the above, while this writ petition is disposed of, liberty is granted to the petitioner to approach the appropriate civil court for redressal of his grievance. Petition stands closed.
10 is also same.
Similar.
Work is different.
Yes, Lord.
Synopsis of work that would be, huh? And the period 16.
It's 15.
16.
Work order was shown 15.
15.
15.
That's column 15. Okay. Petitioner is the same, madam? Petitioner.
No, Lordship, different. Types are given.
Okay, next.
All right.
Much of that.
Eleven. PP Medhi.
Last occasion also they have not applied. Otherwise, if we go by the pair of the recipient, pair is page 12 losses.
None appears for the petitioner on call. Even on the, whereas we, K. Google and the State Council is present. Even on the last occasion, that is 28/4/2025, none had appeared for the petitioner on call. In the interest of justice, a final opportunity is granted to the petitioner to make representation. Based on 6th of February.
Apologies.
Item 12, my lord, can it be taken up next week, my lord? Your pleading is complete, the record is also available.
What is the subject matter?
My lord, settlement of fishery is for 7 years. There is no any interim order.
And the period?
Period 7.
7 years.
7.
No, that you have said. When is it? From which period?
From 2023.
No stay order.
No.
Yes, you want to do it today? We'd like to do it today. You are here. Mr. Chaudhary is also here.
Allows me, I can do it.
No, not allowing. It's for you. We are here to hear.
The only issue is this, my lord. Because there was a complaint that there were some irregularities in the cooperative society.
Who are you?
My lord, I am a cooperative society. Where
You are a prospective bidder.
not prospective, I was technically and financially, I was allowed. I was allowed and I was, because being a cooperative society, within the terms and condition of the NIT, my lord, I get within the highest bidder.
You were one of the bidders.
One of the bidders.
Now, why weren't you given the settlement?
Because, my lord, there was a complaint that there are some irregularities in the cooperative societies.
In your cooperative society?
My lord, that was the internal matter between the cooperative societies, and I have.
Who is for the
violated-
corporation department? Mr. Sharma.
And I have violated clause 6.6, no? 6.6 of the.
If you are ready and agreeable, we can have it today itself. Mr. Chaudhary?
I think my learned friend is not fully prepared. It
No,
looks
my lord,
like.
is that my only contention that, my lord, my issue before your lordship is that the court, honorable court directed that there should be
No, we don't go on a piecemeal basis. If you are starting, we'll start properly, and if you are not starting, we'll have it on another day.
Then, my lord, then on 12th, my lord. 12th is Thursday, my lord.
Well, this court may not be there, but whoever is there, matter will be taken up for. We can make a observation for disposal.
Milan,
Third,
I can prepare plus is my learned friend because I'm
Everything,
enjoying.
I can do it, my lord. Some,
it seems you do not have a good case.
my lord, my only contention is this, my lord. The violation of clause 6.6 was directed to be decided by the AFDC. But, my lord, the authority who has decided he is not entitled to, is beyond his jurisdiction.
Who has decided?
The managing director of the AFDC. But he has decided issue against the selections committee's decision who has allowed me to function. Whether he has the authority, that is the.
If you overcome that, then you will be the highest bidder.
Yes, my lord, I have been allowed to work. And my lord, and another issue is this, my lord, they have said that.
So your contest, your fight is not against Mr. Chaudhary.
My lord,
Yours is more
because,
against
my
the
lord, now,
department.
after terminating. me,
Mr. Chaudhary has become the, is the
No, he has
beneficiary.
been allowed, my
He is the
friends, senior
beneficiary.
friends, client has been allowed to, operate the function.
This is very simple, Lordship, in my opinion. Even their pleadings, Lordship, that also can be discussed.
No, we'll have it, as requested, we'll have it on 12th.
Yes.
12th. Heard Sri P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Sri P. Sharma, learned standing counsel, Corporation Department. Full stop.
he's for AFDC.
No, who has decided then?
AFDC.
FDC. Corporation is not a party.
No, not cooperative, certainly, but is formal party is not required.
Okay. Also has Sri P. Sharma, learned standing counsel AFDC, comma, semicolon, Miss M.D. Bora, standing counsel, Corporation Department, full stop. Sri Ken Chori, learned senior counsel, assisted by, what?
R. Kakoti.
R. Kakoti is present for the respond number 8. 8. Who has informed this court regarding filing of the affidavit in opposition on 22/9/2025. Full stop. Affidavit by the department, official respondents has also been filed. Para, the learned counsel are in agreement to have this matter taken up for final disposal at the admission stage. Para, as requested, list for admission hearing on 12/2/2026.
Yes.
The relevant records may be produced by Sri Sharma, the learned standing counsel, on the date fixed. No interim order.
No interim. My lord, when my friend is there in the caveat, senior friend, I cannot get it.
Yes, madam.
Lordship, I'd like to pray for a little accommodation, Lordship. Lordship,
Accommodation.
Lordship, could this matter be taken up at 2?
Hmm?
At two, Lordship, I have some difficulty.
At 2 o'clock.
At two, I'm suffering from fever. I have to.
At 2 we'll have fever.
No, I'm suffering from.
Oh, you're already suffering. Okay. We thought at 2 o'clock we'll have fever.
No, but for this matter, I came.
Lordship, maybe after some time, Lordship.
We'll have it some other day. That
No,
has
Lordship,
be
we-
okay.
On last occasion, they have taken time to find
What is the
reply.
issue? What is the issue?
This is the issue with regard to the city buses who has been stopped from plying in the route number 23, that is
Okay,
from,
we'll have some other day. We
Yes,
can
sir.
have it on Thursday, day after tomorrow.
if I may, Lordship, on the last occasion, an order was passed whereby the respondent authorities were asked to give us alternative routes for the time being, subject to the outcome of the writ petition. And a lot of the city bus owners have already applied, but they were not allotted any kind of routes and they are now sitting. And from 18th of this month, they're nowhere. The buses are still.
Okay, day after tomorrow we'll have. We'll try, day after tomorrow, madam.
Day after,
Ah.
my lord.
Thursday,
Thursday.
the senior will be there.
Yes, Lordship.
Okay. Heard Miss N. Begum, learned counsel
Thursday is.
for the petitioner. Also heard Miss M.D. Bora, learned standing
Then
counsel,
transport.
Transport Department, para.
Lordship, I'm really sorry, Lordship, he would not be here on Thursday.
Give a date, early date, you say there is an urgency on Friday.
The Lordship, after some time, maybe if,
We don't mind taking, madam is not well.
uh,
On last
Lordship,
occasion also, Lordship, they have taken
I
time to
know.
file a reply of our
No,
affidavit.
that is not the issue. We'll have a date of the convenience of
Lordship,
both
could
the
it be
parties.
taken up tomorrow?
Second, tomorrow.
Tomorrow, Lordship.
Tomorrow, will it be okay?
Yes, my lord.
Okay, then tomorrow. It was
Okay.
judging oil. Okay, last में क्या लिखा? Last one. List again, and list for admission tomorrow. Date.
Please, your Lordship.
Item number.
20. Lordship, this matter pertains to the transport subsidy where for cash, payment of expenses in cash the subsidy was rejected. In the similar matter, Lordship.
Yes.
Lordship, to the utility recommendation, we have no file also, 17 matter, Lordship. I have.
Affidavit.
We have no file also.
Oh, you get the file, but we are not adjourning this matter. We can have it tomorrow, day after. We'll
Lordship,
accommodate you.
What has happened?
17 matter.
Similar
Is it covered?
Yes, Lordship. Similar issue, it is covered, order by the.
You do one thing, you give a copy to Mr.
Lordship, I will
Mr.
verify it.
Yes.
Let them verify, we can have it tomorrow.
But I'm praying that Lordship against this order, covered order, the
Appeal.
petitioner is preferring appeal. So to just avoid multiplicity of proceeding, may I pray that this matter may be kept adjourned for timing in the meantime, appeal may be considered by this order.
Have you filed the appeal?
No, it is under the process of being filed. Lordship.
When was the order? Order passed by which court?
Honorable Justice Devasith.
Regard to your payment of subsidy, whether Lordship, if there is a delay in payment of
So
subsidy.
this order is of which
Yes,
date?
yes.
Lordship by Honorable Justice D. Borua,
Date?
date of 22/7/25.
It's time bound already.
Supreme
22/5.
Court-
22/5/2025, we are in almost the February.
Yes.
So we will follow that. If you are successful, you can attack this along with that.
Only for the time being, in the meantime, whether if appeal is
No, see, if you have filed the appeal, there's an order.
not yet filed, Lordship.
If not even filed, then it's all, apparently it's time barred, time and the delay is not in it. Writ appeal is 30 days.
Yes, Lordship.
We'll follow that order tomorrow. Have a look at the order.
Yes, Lordship.
We'll also record your submission, Mr. Dr. Tudi, that
Order is
the
fully covered.
covered, and this, there's an appeal they are contemplating. So we'll have this
Lordship,
observation recorded.
Can it be day after tomorrow? Yes.
We can have it after some time. You have a look. There's no point, the 17
Yes,
matters.
yes, Lordship, it can be done.
Have a look, Mr. Das, you have a look at the order. And if you have filed, Mr. Dr. Tudi, you get some information. Filed
yet
or not?
Lordship,
Not filed.
because, I have been instructed to prepare.
Okay, not
Ah.
filed. Okay, we'll record your submission.
Yes, Lordship.
Okay, next. It is covered already. I'll come to dismiss for them, and then they are contemplating to prepare. We'll reply. 21 years.
May I please also. Yes, last occasion, Lordship, we have, on Friday, Lordship, we have filed affidavit in office. On last Friday, Lordship. That is not in record.
Mr. Dasgupta, okay.
Receipt.
Have you received, yes, madam, received copy?
Yes.
Okay. Part 3A Dasgupta, learned senior counsel for the petitioner. Also heard 3K Kolita, learned counsel for the
Respondent 1 and 2, Lordship.
respondent numbers 1 and 2, who has submitted that the affidavit in opposition has been filed today
No, Friday, Lordship.
on Friday date, huh?
22nd.
Friday, which however is not tagged with the records. Para. Register to verify and tag the affidavit in opposition with the records. Full stop. Para. The matter be listed for admission hearing on what is the matter involved?
Some liquidated damage has been imposed on the trade union worker resorting strike.
By the labor code.
No, by the employer.
Oil India Limited.
But
Lordship,
the-
Oil India
Oh,
Limited.
it's not
Strike-
against,
Strike was resorted.
Okay.
And the Oil India's condition is.
It is not against any award by the
No.
tribunal or labor code.
No.
Lordship, but we deducted from the contractor, Lordship.
Whatever.
Because
We
Yes,
have
but
No,
resorted.
LD you have deducted as per what? As some clause
Yes, Lordship, as per the contract, Lordship.
from the contractor, and contractor has deducted from, contractor is a party or what? Party.
That is our ground, Lordship. That is
Yeah.
maintained the point we have raised in our affidavit.
But so for the
We
impugned
have
order is,
analyzed the contract also.
Okay.
so for the impugned order is concerned, it is specifically mentioned that due to resortion of the strikes, they have sustained loss and liquidated damage will be deducted.
But that is part of the contract, Lordship. That clause is there.
Why haven't you made the contractor a party?
So, large number of contractors are there.
That's
But
why-
I think the contractor is not required. Because so far the impugned order is concerned, this order itself indicates.
No,
Because.
the immediate action has been taken by the contractor, who are you?
Yes.
The decision is theirs,
Decision is
but
there.
the contractor has extracted money from you
Yes,
to fulfill the LD.
yes.
But I think contractor would be
That's why
necessary. You
Lordship,
think
the-
over, Mr. Rajgupta.
Lordship,
If the matter
initially-
listed,
You think over, we are listing the matter in the first week of February. You think over.
That's why, Lordship, the matter was, notice was issued in the year 2023, because we have raised that point.
no. So far the notice was issued is concerned, the court has asked
Okay,
me.
Rana, কি করবো? Also, so find the affidavit of opposition, কি হলো? তার আগতে কব, take to the record. Sri Kolita has also raised the issue of non-joinder of necessary parties. So, let the office to verify censor. As agreed to by the learned counsel for the parties, this for admission hearing on 11th of February. Is it okay? 11th February? 11th February?
Lordship, if they not file reply, Lordship, let me.
11th February? By which time? Rejoinder affidavit, comma, if, rejoinder affidavit may be filed, comma, if so advised.
Yes. Alim,
What is the IA about?
I for have raised some,
No, this IA has been disposed of.
Disposed of.
Because this point was raised by the Honorable Justice Michael Pangamiller, where the document was not in an act, the liquidated damage. So for that
Okay,
purpose, an
well,
amendment.
IA has been disposed of, we have seen.
But, Lordship, in largest, item number 13 and 14, Lordship has fixed tomorrow. Can it be day after tomorrow?
13 and 14, what matters?
The Metropolitan Transport Association.
Madam Begum had a difficulty day after tomorrow. We can have any other date, Mr. Nath. Bring her to the court.
Okay.
Day after tomorrow, I think Mr. Mohanta would not be there. We suggested day after tomorrow. You bring her or have a talk with her and give a
Yes.
agreed date, we'll have that date.
We'll inform them. Lordship.
We have go through this squarely covered questions.
Okay. Yes, copy.
There was a requirement of checklist there. The honorable court says that is in the
Okay,
public
okay.
interest also.
Third, Dr. A to D, learned counsel for the petitioner. Also heard Sri K. Gogoi, learned state counsel, as well as Sri Zidas. Zidas,
Yes, Lordship,
For-
respondent number 3.
response number 3, full stop. Para. The instant requisition has been instituted
My lord, the paragraph 3 of the order is specific. Paragraph 3 of the order.
is instituted against an order dated 5/10/2015 passed by the additional director, Industries and Commerce Department for payment of the due amount and also interest as per bank loan at the rate of 12% on the principal amount from the date of forwarding of the claim amount, full stop. The petitioner has, and as per the projected facts, the petitioner is a registered company engaged in the manufacture of atta, maida, suji, etc. And is also registered as an SSI unit, full stop. The Government of India in the Ministry of Industry had introduced a scheme called the Transport Subsidy Scheme of 1971, which was primarily for the purpose of industrial growth in selected areas, full stop. This scheme was extended till 31/3/2007 in the northeastern region, full stop. The petitioner had registered for entitlement of such transport subsidy. Full stop. The petitioner had also approached this court earlier for payment of subsidy, and such claim was found to be genuine by this court which had passed an order dated 27/2012 in WPC 1572 of 2009 for a certain period, full stop. However, the transport subsidy for the period from 1/6/2009 to 15/6/2009 has been rejected. And accordingly, the instant writ petition has been filed. Para. Dr. Todi, the learned counsel, has, however, fairly informed this court that an identical issue had come up before this court in WPC 463 of 2020, which was disposed of on 22/7/2025, by which the writ petition has been dismissed. Full stop. He has, however, informed that steps have been taken, steps are the steps are in process for preferring an appeal against the said judgment. Full stop. Para. Both Sri Gogoi, the learned state counsel, and Sri G. Das, the learned counsel for the NETFI, have submitted that in view of the aforesaid judgment dated 22/7/2025, there is no requirement for any further adjudication of the issue, which is identical. Full stop. Para. The aforesaid judgment dated so has been placed on record. Full stop. In the said judgment, the following observations have been made. Which paragraph? 36?
Paragraph 40.
Lordship,
40.
Para 22 and then 40.
22 and 40.
22 and 40.
20.
Question of law is in frame.
22, 40 is the conclusion.
What was the
No,
conclusion?
we wanted to have is it 36? The
22
discussion.
Discussion starts from 23 or
No,
22 point of
that's not
focus.
discussion. Those are not discussion. 23 are your submissions.
Yes. No, first your lordship may prefer para 22.
22, I know that 46, 22, 20, okay, well, 22 and 30, 40. Full stop. Para. In view of the aforesaid position, this court is of the opinion that there is no reason to differ with the conclusion arrived at by a coordinate bench. Full stop. Bench and accordingly accordingly by following the aforesaid judgment, the instant petition is dismissed. Full stop. It is needless to state that not required. We have recorded your submission of the appeal that you know what to do. Okay.
Yeah, IE is also that may also.
Yes.
There is a IE also that may also be.
I in view of this one, so I was going. Okay.
Much okay.
Funny development.
Please, Lordship. In this case, on last occasion, Lane CGSC undertook to file affidavit in opposition, Lordship, in the course of day. I have been served copy also.
Been filed.
Then
Have you been served with a copy?
yes, I have been served copy.
Heard. Sri S.D. Purkast, learned counsel for the petition. Para. Also heard Ms. M. Das, learned counsel appearing in instruction of Sri S.K. Methi, learned CGC. Full stop. Ms. Das, the learned counsel, is informed that the affidavit in opposition was filed by serving copy to the learned counsel for the petitioner, due to certain defects, the same has not been tagged with the court records. Full stop. She has undertaken to remove the defects within 2 days. Full stop. Let the affidavit be tagged with the court records and the matter be listed for admission on 6th of February.
15, I think.
15.
This
Yes,
matter
Mr.
pertains
Mukherjee?
to disconnection of electricity at the instance.
Okay.
There was an interim order, and pursuant to the interim order, I have applied for electricity connection. Temporary connection has already been provided.
Okay. What is your instruction, Mr. Das?
Here are no opposition of this premise. Here are tenant.
No, on the merits of the case. Now we have given temporary connection. That is not the end of the matter. The matter needs to be thrashed out. You would like to file affidavit? Or if you, on the basis of your instruction, if we can take it for disposal, we'll take it up.
My instruction is that my lord, temporary connections can be granted. Yes.
What was your grievance?
Lordship, the landlord disconnected the connection and they insisted for an NOC from the landlord.
Now they have given it.
Now they have.
I think they'll continue it in accordance with law.
Yes.
Okay. Heard. Sri B.J. Mukherjee, learned counsel for the petitioner. Also heard who are the state is there. Also heard Sri K. Gogoi, learned state counsel, and Sri B. Das, learned standing counsel, APDCL. Para. Considering the facts and circumstances, the subsequent development, and as agreed to by the learned counsel for the parties, the instant writ petition is taken up for disposal at the admission stage. নকবা ইয়াতে বহিব লাগিব তুমি নহ'লে at the admission stage. What is an admission, Mr. Court Master? At the admission stage, full stop. Para. As per the facts projected, the petitioner is a tenant under respond number 5. And there is a move by the said respond number 5 to illegally evict, not to say eject, evict the petitioner. And as a and as a tactic, the electricity connection has been disconnected. Electricity has been disconnected. Full stop. The landlord had also refused to give any NOC to the petitioner to get a separate electricity connection. Full stop. The present petition was accordingly instituted. Para. When this matter had come up for consideration on 3/4/2024, notice was issued by this court with a further observation that pendency of the writ petition will not be a bar for the respondents to consider giving electricity connection to the petitioner. Para. On the subsequent occasion, on 19/4/2024, when this matter had come up for consideration, this court had made an observation regarding grant of temporary connection. Full stop. For any reference, the aforesaid observations are extracted herein below. Paragraph 8 of order dated 19/4/2024. Para. Sri B. Das, learned standing counsel APDCL, has submitted that the aforesaid order has been complied with and temporary connection has indeed been given to the petitioner. Full stop. The aforesaid statement of fact has also been endorsed by Sri Mukherjee, the learned counsel for the petitioner. Para. The aspect of grant of temporary license is within the terms and conditions of supply of the APDCL, wherein a tenant is permitted to have electricity connection in his own name, and if NOC is not available, he is required to pay 3 times the load security. Full stop. It appears that the petitioner has complied with the aforesaid requirement pursuant to which the temporary electricity connection has been made. Full stop. Para. In view of the above, this court is of the opinion that there would be no requirement for further adjudication of the matter, and the electricity connection and the temporary connection so made is to be sustained subject to fulfillment of the conditions as required in law by the petitioner. Full stop. The present order, however, shall not have any impact on any litigations pending or probable between the petitioner and the respondent 6 with regard to ejectment of the suite premises. Yes,
Lordship, in the-
I have for
Lordship, I have for implement, Lordship.
implement,
Lordship.
implement of
Implement of Lordship L1 bidder. Actually, Lordship, I have sought for instruction, Lordship, from the petitioner, Lordship. So sometime maybe not, Lordship.
Oh, you are not the petitioner.
Lordship,
You want yourself to be included.
He wants to be the successful bidder
Successful bidder, L1 bidder.
whom we have issued the LOAs. The petitioner says that
How have you structured your petition? See, what have you written in your cost title? An application filed by the applicant herein for being implemented. It gives the impression that somebody wants to get himself implemented. If you are the petitioner, this is not the language you should employ. You appear for Konkan,
Lordship,
then you are the petitioner.
Lordship.
You are the applicant. You want somebody to be implemented as respondent number 3. Whom? TZIPL. We can get it included. What is the difficulty? We can allow this.
I have no difficulty, otherwise he wants to obtain.
Why do you need instructions?
Lordship, actually, the matter was conducted by Mr. London Senior Counsel, Mr. Didas. Lordship. Anyways, Lordship, we haven't received any instruction from the petitioner, Lordship. That is the issue, Lordship.
No, we can pass the order. We will go one step
Okay.
ahead.
As per,
Or you take instruction. You get come back if he is available. Who is the senior?
Lordship,
Who is the senior?
Arhavarika was there,
Arhavarika.
Jero was there.
Have a word with Mr. Roy if he's, otherwise if you want.
Lordship,
we
he
can
is on
run
that,
sometime.
maybe after some time, Lordship.
Okay, you come back if you are there, otherwise you are passing an order. What is your name?
The BP Sharma.
Sri BP Sharma, Learned Counsel for the. I heard Sri BP Sharma, Learned Counsel for the applicant as well as Sri K. Gogoi, Learned CGC. Para? Sri Sharma, the Learned Counsel prays for some accommodation. List on Friday. Or if you have some word, you can come back. We can just allow it now. Okay, we'll change the order. Okay. Yes. Where is Mr. Bhuya? Please ask your colleague to have Mr. Bhuya. No, we'll just have, he should know about it. You need not be bothered. You ask your colleague to be. No, we'll look into it. We'll look into it. Okay. Okay.
Last order is 20.1/2026, my lord.
Yes.
This is what asked to file affidavit, my lord. And we have filed the affidavit, my lord, upon the first order. That the admitted amount.
Yes, yes, we took exception because if we have filed the affidavit today.
Yes, yes.
You have been served.
Yes, copy has been served.
Yes,
sir.
what do you say?
I'll take my instruction, whether they have received a 50% amount or not.
Okay, we'll have it some other day.
Yes.
Okay. Heard Sri B. Das, learned counsel for the petitioner, para. Also heard Sri A.K. Bhuya, learned standing counsel BTC, who has submitted that in terms of the order dated 21/1/2026, the affidavit, additional affidavit has been filed today, which has also been brought on record, para. Sri Das, the learned counsel, prays for some time to obtain instructions on the stand taken by the BTC authorities, para. As agreed to by the learned counsel for the parties, matter is adjourned to be listed on
March, my lord.
on 2nd of March,
Yes, and until any possible, my lord, payment will be made.
2nd of March.
Okay.
Puts the pendency shall not be a bar for resolution of the dispute between
yes.
the, no, don't say pendency shall not be a bar for full compliance of the order in question.
Deeply.
No, don't say pendency shall not be a bar. Last line not required. Contemplate or co-bookers. This. এই যে হেৰিটো আছিলে তাতে এটা লিখিব লাগিব non-appearance of the respondent members, private residence shall not in view of the order proposed to be passed, absence of the respondent of agency shall not have any effect. এই যে হেৰিটো electricity. Yes, Mr. Mish.
In this case, my lord, I have come against the order passed by the labor court, my lord.
Yes.
Award passed by the labor court, my lord.
Yes,
So,
Madam Bhattacharya.
Madam Bhattacharya, I think, my lord, she was not find me today.
She is there or not in the court?
I have not find her today morning. I was.
You are the management.
Management.
You are aggrieved by what order? What
The
award?
award passed by the labor court, my lord.
What is it about?
My lord, the two reference cases were there, my lord. First was that she one increment, one salary was sought to be given to him. And taking that plea, my lord, one reference was made and it was disposed of. And in the meantime, my lord, some departmental proceeding was initiated against the workman, my lord, and he was terminated. During the while the departmental proceeding was taken up, my lord, the reference case, reference case number 3 of 2004 was pending. Accordingly, 33 petition under 33 rule
C2
was filed, my lord. That was pending, and in the meantime, my lord, the reference case was disposed of, saying that there is no reference, there is no issue, so we are not addressing the issue raised here. Then, my lord, during the taking plea of that order, my lord, that award, my lord, the miss case 33-2 petition file, that was disposed of, saying that as because the entire reference case is not before us, so the miss case has no kill, so we are not dealing with that. So it was dismissed. Thereafter, my lord, taking by that order, against that order, the workman came to the High Court after his termination. High Court allowed their prayer, and the earlier reference case continued.
Okay.
Then earlier reference case continued, and the award was passed that the difference of amount, that means the grade 3 amount he was given, not given the grade 2 amount, that difference has to be paid. That is there. After 10 years of that order, termination order, this reference was made saying that this termination is bad. This termination is bad.
There is a direction for reinstatement.
Not reinstatement, but the difference of the amount has to be paid. The issue of termination was not before the High Court.
And there
We'll
also,
have, we'll try day after tomorrow. Yes,
see, I have not found
day
her
after
today morning
tomorrow, day
also.
after tomorrow, because
Day after tomorrow.
workman is there, okay. While Sri M.K. Mishra, learned counsel for the petitioner, is present. Comma, the contesting workman represented by Miss M.S. A. Bhattacharya. Present, comma, Miss A. Bhattacharya, the learned counsel for the contesting workman, he is not present. Full stop. The state, however, is represented by Sri P. Gogoi, the learned state counsel. Para. In view of the above, and in the interest of justice, consideration of this matter is adjourned to Thursday. Please give the date. List accordingly.
Hello, I'm sorry. The one matter before your lordship, we have some urgency. Other side has difficulty tomorrow. Again, I have some difficulty later on.
Now, tell us a date of your convenience.
Sorry.
Tell us a date of your
Or
convenience.
if not difficult for them, we can proceed today itself or lordship permits.
Senior counsel is that, senior,
Who's there?
that for RTA board.
No, we'll have another date. We have already passed orders. We'll accommodate you. There is urgency. We'll have it immediately on the next week. If tomorrow you have a difficulty. What about Friday?
Tomorrow I can. They said that they have difficulty.
Thursday, you have a difficulty. Friday?
Friday, Thursday pain ki even. No, ठीक है 29 to ले लो.
29th?
29th.
29th, we had suggested 29th. 29th, we had suggested. We had suggested, in fact.
Thursday.
Your colleague said no.
Yes,
29th we'll have.
29.
Okay. Couldn't legislate. We'll have it on 29th.
Right.
What is the issue, Mr.
Well, this is regarding the ousting of the city buses from two routes.
Oh, yes, madam.
Yes.
Yes. Now we are nowhere.
Yes,
Now, no routes have been, alternative routes have not been
No.
given.
they suggested, but not yet. Some interim order was there, that will continue till.
Oh, there is an interim order?
Yes.
Okay.
Interim order, very specific,
That is what is heard.
Whatever is there,
Yeah.
interim
whatever
order.
is there, because they are asked to apply for the alternate route.
Interim order
which is
passed
there.
earlier to continue till the next date of listing, huh?
But there is no blanket interim order.
Whatever is there.
Whatever is there.
So, you are replacing everything by the green buses,
No, no.
then?
False statement made by the petition.
No, no, it's not a false statement. It can be an incorrect statement. Don't use expressions like false.
Lordship, I have received.
Not false, incorrect. That is not, you have to use dignified expressions in the High Court. False, these that are not allowed. We will not allow you. Incorrect, say incorrect.
Lordship, may I have-
Okay, day after tomorrow, come prepared.
Yes.
Day after tomorrow.
Yeah. Okay, it's next.